I'll be on top again. I'm not gonna let you take me down. It's gonna be the whole nine yards or nothing.
Hi, I'm Jerry Parisi, and welcome to tonight's edition of Legal Straight Talk. I'm sitting in for my good friend Tom Mealy and Brett Harrison. Brett's out vacationing, and Tom is controlling the world. He's doing it one case at a time. And I'm very lucky here to be here with a very good friend of mine from our past. And she is the person that everyone who does any type of entrepreneurial work does know. I'd like to introduce to everyone Miss Betty Tufariello. Betty, well, I was almost going to say paginata. Betty Tufariello. Welcome to Legal Straight Talk. How are you?
I'm so well. How about yourself?
You know what? Outside of the amazing amount of people who watch this show, I'm very, very honored to be here today in place of my friends. And to be with you, to me, it's wonderful. But let's get right down to business. People don't want to hear about our past. They want to know about intellectual property. And so I guess one of the first things we should all know, Betty, is when you start a project, be it a movie, a new invention, anything like that, what are our first steps that we got to do to protect that little germination of an idea before it starts getting out there?
That's a very complicated question.
Aha.
That has so many different avenues. It could take more than just 20 minutes to answer, and you know from our past history
That's
just
right.
how complex
That's
it can
true,
be.
yeah.
Well, it depends on what it is that you're doing. The most important thing is whether the business or the entrepreneurship that you're putting together is based on an invention. If it is on an invention, then that invention should be thoroughly protected. And there's two reasons why you want to protect it. The first reason is because you want to add value to your company right from the get-go. Most of us would love to be able to license our invention or start a business based on the invention, and once the business is actually off the ground, to perhaps get bought out.
Sure.
Dreams of being bought out for $5 million, $10 million, $25 million. Well, in order for you to do that, you really need to protect your invention through the patenting process.
I can see why you said it was such a broad question I asked. There's so many different avenues. So, all right, let's then simply start with, I've got an idea. I want to have this invention, and whatever this invention is, this widget does something. It maybe makes your water more pure, or something you can go away with, or something that adds value to someone else's life. And let's start with that. Let's just say it's a widget that adds value to someone, sort of like a brush bracket or something of years ago.
Well, I'm really glad that you mentioned a widget, because ideas by themselves are not protected.
Okay.
There are basically 4 different intellectual property classes of things or areas of law. We have patents, we have trademarks, we have copyrights, and we have trade dress. Those are the basic 4 categories of intellectual property law that someone like me, an intellectual property attorney, will use to protect not only the invention, but the company that's going to put out the invention and the people behind it. My firm in particular likes to say we don't protect ideas or inventions, we protect people and we protect companies.
So,
that's what we do.
All right, so we got this widget here, and I would come to you, let's say, and I said, this widget does this, that, and the other thing, and it takes off on Sunday, whatever. I mean, I don't have anything other than a widget and showing my hand as an example.
Right.
What's your first step? What do you need from the client or the person coming to see you to begin this process going?
Well, it depends on where we're in the process.
Okay.
If that widget is already out on the market
Right.
and it's already being marketed, the first thing that I would like to know is what are they doing to promote this particular widget? How are they driving the consumer to have an interest in the market? And usually most of the companies that I deal with, they deal with logos and with trademarks.
Okay, that's a good area. Let's start with that. So would you want to see from a person like myself, or the client as it will be, would you need to see the logo first, or do you see some paperwork on the actual widget to know how it works so you can get a firm grasp yourself on what we're working with? Tell me that.
Well, usually you have a word or some sort of phrase or some sort of logo or a color or a shape. See, trademarks are very unique because anything can be a trademark. By definition, a trademark is nothing more than a shorthand version, like secretaries that take shorthand,
Sure.
a shorthand version of communication to the consumer so that when they see that logo, they immediately know who the company is or what company this particular product originates from. So a trademark is really a very shorthand method of communicating to the consumer the source or the origin of that particular product. So this way, when the consumer sees that, they immediately associate it with the company, and depending on their experience with that company, they're going to make a commercial decision. They're going to make a decision to purchase this item because they know that this particular item comes from this company or comes from this other company. So for example, someone who really likes Mustangs,
Okay.
right? A Mustang has a very unique logo. You're going shopping for a car. You can spot a Mustang immediately, and you know that's a Mustang and that's coming from Ford. And so you're going to make a decision to purchase that car because you have come to have a certain expectation of performance and quality for that particular Mustang. So if you're a big fan of a 1966 to 1972 Mustang, you're going to purchase that because that's your expectation. If you like a particular line of makeup, Estee Lauder, and you're looking for an Estee Lauder product, you're going to walk into the mall, you're going to go into Macy's. Estee Lauder has a kiosk in Macy's. And so even from afar, you're going to look for the colors of that kiosk. And you're going to say, oh, well, there's the Estee Lauder kiosk. That's where I'm going to go in order for me to buy the makeup that I'm looking for or the skincare line that I'm looking for. So logos immediately communicate to the consumer what the source of that product is, or who the company is that's manufacturing it, or is it affiliated with that company, or in some way that company has approved it or has put its stamp of approval that this product is it's coming from them. And so when the consumer sees it, the consumer immediately knows that this product comes from that company.
So that's the importance of a logo. So let's say I've now walked in, I've got my widget right here, and I've got my logo. And my logo might be like two fingers. This
Right.
might be my logo,
Right.
okay? So I've now come up to you and I said, hi, Betty, I've got this logo. It's not trademarked or registered. What would be someone's first step? They've just got this done by a graphic artist or an art director, creative director, whatever level of designer they've worked with, and now they come to you and they're excited, and this becomes the visual signature of that product.
I like that, the visual signature of the product, the visual signature of the company that makes that product.
Okay.
Okay, well, the very first thing that I usually ask, did you do a trademark search?
Okay, I didn't do one, they say.
Well, then we may have a problem, especially if they've already adopted the trademark and then been using it in business for a few months.
I see.
And they've already invested. Because if they didn't do a trademark search, then they have no way of knowing whether, in fact, they have clear title to that trademark. What that means, clear title, that's legal jargon. What that means is, are you in fact the first one who adopted this particular logo to use with their service or with this product, or is there somebody else ahead of you? So you need to do a trademark search to see if anyone else has in fact adopted this trademark in connection with their goods and their services.
Okay.
And if they have, how close are those goods and services? And if they are close, then is there a likelihood that a consumer that sees your logo and is familiar with the prior company's logo, is a consumer likely to be confused about the source of the two products? And if they are confused, either they're confused that your product originates from that other company, or that product of the other company originates from you, you can potentially lose sales because the consumer now is buying that other product because they're confused into thinking that that product belongs to you.
And I know when you go to a supermarket, for example, you have the identical Parity packaging, brand here, and what really is their overflow is in the same bottle, a brand X type of a logo, and you look at it and you have to say, gee, it's so close, which is which. Usually it's a derivative of that product, say watered down. But let's get back on the logo.
Right.
So we got this logo, and what
We
you
need to do a trademark
right.
search.
So we find that somebody's widgets look like this logo, and our widgets look like this, which now becomes very, very close. Mm-hmm. And you're going to probably say, this is too close, we have to modify it.
Well, you're moving a lot faster in the process than usually. My experience has been when people come in and I say to them, well, have you done a trademark search?
Right.
Okay. They'll say, well, I got the domain name.
Okay.
Or better still, my lawyer, I got an LLC and I went up to the state. My lawyer, checked with the database of corporations in the state of New York, if it's a New York corporation.
Right.
Or my attorney checked with the Secretary of Delaware, if it's a Delaware corporation. Usually that's what happens. If you're in New York, you're either filing as a New York corporation or you're filing as a Delaware corporation. And because they were able to secure the name as a corporation, they presume that now it's available as a trademark.
So the name, the widget, and now the logo
Right.
have to somehow be, I guess, put together that creates that visual look of a company.
That's correct. And we need to make sure that we can do that and we're not stepping on the toes or
Of the other
trampling
logo.
of the other company.
Right.
Exactly. So they'll say to me, well, I have the domain name, I can go ahead and use it. Well, that's incorrect. Because the databases that give you domain names or the databases that give you corporate names don't do what's called a trademark search.
Aha.
Because a trademark is a source identifier of the goods, and you have to go to the appropriate trademark database. And that trademark database is either at the federal level or at the state level. So the trademark search has to be done at the Federal Trademark Office, where they have their own trademark database of all the federal registrations. And it is so broad that it covers corporations not just in New York or Delaware, but every federal state. So if there's a company, for example, in California, they would have filed to register their trademark in the Federal Trademark Office.
Okay.
So just think about it for a minute. If your attorney just checked the state of New York or the state of Delaware,
Right.
they never saw the state of California, did they?
No,
They
of course
didn't
not.
see Washington, state of Washington.
They didn't.
So because of the federal registration program that is in place in this country, companies that are beyond those states that you would normally do business, they would register their trademark. So that's the first place the trademark registration, the trademark search has to begin. Now, trademarks, rights to trademarks, come from use, and not only should you be checking the federal trademark database, you should also be looking at the state trademark databases, because trademarks are in the domains of both the federal government and the state government. And so a proper trademark search should be actually done both at the federal level and at each and every state.
Okay, so let me understand, and up to this point, it sounds to me is that you should not go forward with this, that, or the other thing until you synchronize everything at once. And let's say, in this case, speak to an attorney to say, before I file this, before I design this, because usually you'll give something to somebody that's in your own conceptual mind, and they'll create it up. And before I go out and buy a domain, they should sit with a patent attorney or intellectual attorney such as yourself, or somebody that will synchronize this and then move forward. So what's the first thing you would want to say? That what's step A, what's step B, and what's step C to A, creating a corporation, B, getting a domain, and C, designing that logo.
The first step you should do is actually make up your mind how many different names you have, because the first name may not be available.
Okay.
So when I have a client that comes in to see me for a potential trademark, and they only have one in place, I always warn them that there's a very good likelihood, there's a very good possibility that that name might not be available. Because this country has been in business since 1776, and there's been a lot of corporations out there. Many have come and gone, but there are a lot of people doing business out there, and it's much more likely that your first choice has been taken. So what happens is we engage in a lot of conversation. We understand what the goods and services are. We understand the consumer. This is all very important. We understand the unique value proposition of the product or the service. We try to identify what's really unique about the product or the service, and the niche that this particular product is going to fill.
It's salient.
And once we understand all of that, now we can put a logo and a name together that will immediately attract and hold the consumer.
So let me ask you this. Now that a person has gone to the intellectual property office with the three mindsets, and you're going to send them out and say, okay, I need you to come up with maybe 10 names. It sounds like it would be a good idea for that person to have done his research then on what his widget is actually going to do.
Yes.
So now the real first step is know what your product, service, or wherever that's going to be is going to do, because you're going to probably have the questions. They're going to say, well, does it do this? Does it do that? Will I enhance my life? Or is this a parody product? You'll need to know that before you send them off and say, okay, come up with these names.
Let me just ask a question of you. When you say a parody product, what do you mean? Because to me as an attorney, especially as a copyright attorney, parody can have 4 or 5 different definitions.
Yeah, this is a tough one.
So when you say parody product, I'm sitting here going, what is he talking about?
All right, well, a parody product is something identical to something out there already, but it's done cheaper, faster, or better.
So you're talking generic?
Let's say generic is good.
Okay.
We call it parody in the ad world. You're calling it generic. I see where that goes.
Okay. Well, there's a lot of those products, and actually many of the generic or what I call private branding. This is happening a lot in the cosmetic industries, for example. Very specifically, I could point out, because I've actually gotten confused myself.
Sure.
You know, there's a particular eye makeup remover that is made by L'Oreal, and a lot of the big pharmaceutical out there is pharmaceutical companies, and more specifically the retail pharmacies like a CVS or a Walgreens or a Walmart. They actually work with L'Oreal and they private label in generic format.
That's right.
So now when you go up to the shelf, right, you have, let's say, the L'Oreal makeup remover on the left, and you have the Walmart item on the right.
That is right.
And when you look at them, they have the same height as a bottle, the same shape, the same color, the same general characteristics. And it's not unusual when you're rushing, and it's happened to me numerous times, where I will pick up the generic product, go home, and feel pretty silly because I picked up the generic product as opposed to the name brand product, which is what I intended to do in the first place. That's something else, because that falls into the area of licensing. And the major manufacturers like a L'Oreal, in this particular case, or any other Oil of Olay makes it a lot. There's, you look at the packaging and you see that there's the generic brand, which is a couple of dollars less than, that's all done by agreement. And there's a certain understanding that this may very well happen between, the name brand company that makes it and then private labels it for either the Walgreens or the CVS. They're not doing anything wrong. It's the same quality product.
Sure.
It's just a little less expensive, and it gives a bit of help to the consumer. If that's what you're calling parody, then I understand.
Parody.
But that's not what we're talking about here.
Exactly.
That's not what we're talking about here. We're talking about, I'm a young entrepreneur.
Got it.
I have a great product, and I have to put it out into the market.
And so you've done your research.
Let's presume for a moment, because let's presume for a moment that patents have been filed, inventions have been protected, all that good stuff before we go to market has already been taken care of. And the entrepreneur is working with a great patent attorney, so that's all taken care of.
There you go.
So now we're going in and we're saying, okay, I want to market it. How am I going to attract attention to it? How am I going to make it stand out? How am I going to make it unique? How is it going to stick in that consumer's mind? When you ask yourself those questions, now you're in the process of picking the right name. There's a great book out by Guy Kawasaki called The Art of the Start, and he just actually printed the second edition. And he has a whole chapter on how to pick the right trademark for
Wow.
yourself. And basically, he has a couple of pointers. He says, if you're going to pick a trademark, okay, you want to pick a trademark that starts from A to M. Why? Because most of us go to trade shows to promote our goods and services.
There you go.
And there's these ledgers, these books where all the booths are, put on in that ledger, and they're usually alphabetical. Well, you want to get the visitors at the beginning of the alphabet, not at the end, because if your trademark starts with a Z, you're going to be the last booth at
Absolutely
the end.
correct, yeah.
And so by the time the consumer rolls through to you, or the buyer, the potential buyer, or the potential licensee, because a lot of us take our products and bring them to these licensing invention expos, okay, because there's so many different
What an
trade
amazing
shows.
amount of facets.
Okay, so you want to pick a name that's, from A to M or A to L, because this way you'll be at the beginning of the trade show, and as visitors start cruising down, they're going to see you. It has to be unique. It has to, and another thing about a trademark is it has to have verb potential.
Verb potential.
Verb potential.
That's
Okay.
Let's explain verb potential. I love that word.
Verb potential. And as a matter of fact, Mr. Kawasaki, who I adore, says many, many times, he says, put your trademark just take a blank line, put the word "it" with an exclamation mark. Google it. Xerox it.
Wow. Betty,
Clean it.
I am blown away by the amount of things. But before we go any further, and then sum everything up, because we're going to need to sum everything up in the next few moments. If need be, and someone wanted to contact you for your services, what's the best way of getting to Intellectual Law, your company?
Best thing is just either Google my name, Betty Tufariello,
All
which
right.
is Tufariello.
Right.
And to remember it, just remember number 2, number 4, color yellow, Tufariello.
Well, there's our website where you could probably say.
Or Intellectual Law, INTELLECTULAW.
Wow.
And it'll bring you right back to our website, and it's chock full of information and links where all these various areas of intellectual property are actually discussed at great length, and also resources for inventors and entrepreneurs.
Well, I got to say this. So first of all, now that I know that there's so much that someone has to do to get out there, and there seems to be so many facets, I would understand that it's probably really important to A, do your homework, get to know whatever you're doing and know your salient points, get them out there, have them ready for a person like you to sit down. Then, when they've got that together, you would instruct them to get the several names together on where they want to go and the best way of speaking the corporation or the service or the product. Then from there, I guess you would check into the domains to make sure that's available, and I guess synchronize it, because if widget A is not available and it happens to be called widget A, you might have to call it widget B, which might be available.
That is correct.
And then, once you've determined all of that, let's say in an office visit or 2 or 3, now and only then, once that's all solidified, do you go out and get your graphic person to start beginning with a logo. And of course, there'll be another whole topic on how all that's done. But I know you'll be back on Legal Straight Talk. And I got to say thanks to Tom Mealy and to Brett Harrison for allowing me to host tonight's version of Legal Straight Talk. I know Betty Tufariello of Intellectual Law will be back, and there's so many facets. It's amazing how far and how many there are. And you've done just what this show asks for each of the people that's on it to put it in layman's terms to really get an idea what's going on.
Thank you for having me.
I'm
pleasure.
honored. Stay tuned for the Filmmaker Show right here on Madhouse TV, where Betty continues her conversation. And we look forward to seeing you on Legal Straight Talk next week. Or if you're on Channel 20, we look forward to seeing you at the various times that each and every one of our show is posted on Long Island Cablevision Channel 20. Hi, I'm Jerry Parisi. Join Tom Mealy and Tommy Marr right here on Cablevision Channel 20 each week for an interesting episode of The Long Island View.